All rise. The Court of Appeal in and for the 5th District and Sixth Court is now in session. The Honorable Harvey L.J., Chief Judge presiding. All persons having business before this court draw near, give attention, you will be heard. May God save the United States of America, the state of Florida, this honorable court.
Good morning. We're here about a minute early. As you probably know, my name is Harvey J. I have the privilege and honor of being Chief Judge of this court. I will be presiding today. I also have the honor of two esteemed colleagues, longtime trial judges, one from my hometown of Jacksonville, Judge Soud, another from Palatka, Putnam County, Judge Boatwright, and just a couple of brief things before we get started. We're here for a purpose. We don't always grant oral argument. Why we grant it is to ask questions. And that doesn't mean necessarily to answer the question where you may, in a way that seems to be conducive to what we're asking. It just means we would like answers to certain questions. Why do I say that? Because that's in large part the purpose of why we're here. And I know we've got some very fine and able lawyers. I know you know that before I say it, but a lot of times lawyers want to run around questions, and that becomes frustrating when we're here for a purpose to ask those questions. The second thing, unrelated to that, is if you have electronic devices that may go off, may alarm, if you would be kind enough to turn those off or silence those for purposes of today, that would make for a more seamless video, but I may have just learned that perhaps the video is down. So it's not down. It is running?
It's running.
Okay. So the information I just got is a little different than the truth, but so be it. Mr. Lee, are you prepared to? All right. And we will start with Christie versus Publix, case number 2025-1184. Brian Lee on behalf of Ms. Christie in this case. Would you like to reserve any time for rebuttal, Mr. Lee?
3 minutes for rebuttal, Your Honor.
3 minutes. When you're ready, please proceed.
Thank you, Your Honor. Again, my name is Brian Lee. I'm representing Deanna Christie in this appeal coming from a summary judgment that was entered by the trial court based upon notice. The trial court found that Ms. Christie did not submit enough or evidence of either actual or constructive notice, or that a jury could find actual or constructive notice knowledge under the particular statute. That's why we're here, is that we believe that there was sufficient evidence to give the jury the ability to find either actual or constructive notice in this situation.
Let me, if I may, start with constructive knowledge, and then we do have some questions about the actual knowledge claim here. But the claim on behalf of your client as to constructive knowledge, as this judge understands it, and please correct me if I'm wrong, Mr. Lee, there were drops of water in the aisle, correct?
Yes, Judge. One thing I would change, there is a discrepancy in the evidence of whether there were drops versus there was a puddle of water.
Well, I'm going to get to that.
Okay.
So
water in the aisle,
but
certainly.
As I understood Mr. Wainwright's testimony, I went through and read everything again last night. He said that there was a trail of drops down the aisle.
That's right.
And then he also said that the U-boat, I know it said U-bolt with an LT, but it's actually U-boat,
right,
was dripping water, not pouring water.
There was a little, he did say at different points, Judge. There was one point I believe he said that it was like a spring. That's kind of how he categorized it. To me, spring is not dripping, right? It's something that's kind of coming out pretty, maybe not heavily, but it's a steady stream. But there is There is some back and forth about, okay, well, are they drops or is it water?
Let me ask you about that. You may talk us out of your argument. If it was pouring water, that means it was less likely it was there for a significant amount of time. You would agree with that?
It could have been there for less time. We don't know.
And I thought I read, I just read it, I think it was 464 of the transcript, I think. He says drops, dripping water, not
down the
pouring.
aisle. That's
But
correct.
I thought, I remember him saying this U-boat was dripping water, not pouring water.
He did. He did say that it was dripping water. That's correct.
Because, if it's pouring water, that's a whole different paradigm. You would agree?
I would agree.
Okay.
Yes.
So, again, we want to make sure we look at this in the light most favorable to the non-moving party, your client. So drops of water on the aisle, dripping water, according to 464. And then Ms. Christie describes this puddle as being either 4x4 or 3x3 feet, so a big puddle.
Right.
And then Mr. Clatterbuck is there in the aisle unloading these water jugs, and I thought I read had been there for up to 45 minutes.
That's the testimony. He had been there for quite a while. He was actually, I think the testimony was that he had been doing it for quite a while, and he was even talking with one of the vendors there for a while as well. Another vendor, not the water.
And so is that a feature of constructive notice too?
It is, because we're talking about, and this is akin to the previous cases that this court has had. Very late, I know it was yesterday, but I did do a supplemental authority of the Odrago case, which is what this court did, and talked about Markowitz, which I did cite in my brief, and the vicinity of employees in the area to where a spill occurred or drops or whatever water occurred. And that is something that, even way back in Markowitz, talked about that would be a feature of something a jury could look at for constructive knowledge, because just being there and knowing that the company, or in this case Publix, has the duty to inspect, the duty to maintain those types of things just under general common law. If an employee is in that area, then that would lend itself, or would be evidence that would be sufficient to go to a jury based upon, for them to say that there's constructive knowledge there. And this court reiterated Markowitz in the case that I mentioned.
So coalescing all those things before we get to actual knowledge, which
Sure.
will be next on the question tree, you would say those facts in a light most favorable to your client would be sufficient to show knew or should have known the presence of this Publix employee, the dripping water, the drops on the floor, and the large puddle indicative of a long period of time. That would be your position in a nutshell.
Correct.
Even though there are no track marks, no mud, no dirtiness, that was unequivocal in the record.
That's correct. And marks that is something that I see a lot in cases where there isn't anyone nearby at all, and they want to try to find out how long it's been there, because there is no employee that could sort of be there to look at it, right? It's something that they're trying to figure out the length of time. And skid marks and cart marks, footprints, those kind of things are there. I did note. Oh, excuse me, I didn't note, but I'm thinking back to my other case of Odrago, but in that case it noticed very specifically that trial courts cannot determine length of time, or saying another way, can't determine whether a particular length of time is sort of a bright line rule, that if it hasn't been there for more than 1 minute, 2 minutes, 3 minutes, then that means that you can't have constructive notice of it.
Well, and you've got that, you've cited, is it Bray versus Nike?
Bray versus Nike.
That's a Northern District case.
That's correct.
Saying just that.
Right.
But I guess you would say different than that case, this puddle, this pool of water, given the dripping U-boat, would be sufficient to show at least a jury question on knew or should have known.
Right, and even if you were just looking, even if the court was just looking at that bit of evidence just by itself, when you then combine it with the fact that there was an employee literally right there and had been there for some time, and I think you can also add in the testimony of that same employee, if I'm getting the wording right, that employee said, "Well, I don't normally even look at the floor anyways. When I'm out there doing my job." That, and it's kind of putting all that together, I think each individual fact would lend itself to a summary judgment being not granted. But when you add them all together, it certainly is enough evidence to go to a jury for that.
What about actual knowledge? And we do have Barber and we do have Dolgan from this court. Dolgan, I believe you were involved in that case, Mr. Lee, but we actually didn't need to say that in Dolgan because there was actual knowledge because there was a wet floor sign of water on the floor. But in Barber in 2001, we talk about potentially the creator of a peril, the creator of a hazard, being liable under an actual knowledge theory. Did all that change, though, with the statute in 2010? I
don't believe it did, Judge, because the way that I read and the way that I've briefed Barber, actually even other cases, the cases that defense has done supplemental authority, cites to Barber. The Fourth District case. Said something different, but it's cited to.
Judge Lott's opinion.
Right, and so what Barber said, and the way that I look at it, is two different things. You can either, because there's an or in between it, you either knew about it or created the condition. That's how Barber is set up. You knew about it, or you created a condition. It's not both. So there is no and there. Meaning that you have to, you as the publics have to both know that you did it and you have to create it to have actual notice.
Well, let's look at Barber. Barber, and I'm reading from Barber, and I'm looking at it looks like page 957. When the negligence which produces the injury is that of an employee of the defendant, then the matter of the employer's knowledge of the existence of the dangerous condition becomes inconsequential, because the knowledge of the employee is chargeable against the employer, and his negligent act committed in the course of employment is binding upon the employer. So, I mean, in one sense, there is an and I will tell you, this is not necessarily the easiest question. Barber is what it is. Barber seems to be cited quite a bit.
Right.
Barber also predates the statute.
It does.
So what do we do when there is evidence potentially that a jury could rely upon to conclude that the conduct of an employee created the peril causing the injury? Do we even need to get to knowledge?
You mean that they actually knew that they had created it? Is that what you're asking me?
Yes. Is knowledge even
you don't need that in that situation. That's what I'm saying. You can have either. To me, and this is what I'm arguing, is that actual knowledge can be shown in two ways that I know of. It could be shown as you knew about it, meaning that an employee drops water on the floor, sees it, okay, that's actual knowledge. But you can also have actual knowledge when an employee does something and there's a little bit of kind of wordplay in the cases where it says negligently, right? They do something negligently to cause a condition. You don't need to have the knowledge. You don't have to have the employee know that they did that.
But you're saying that's the second way by which actual knowledge can be. I mean, Barber seems to say knowledge is chargeable.
It's chargeable, correct.
I'm questioning whether or not knowledge is necessary if the statute expressly says in subsection 2, duties under the common law. Continue.
Right, and I think that's where, and I'm being a little presumptuous here, but this court, in cases like this one and in previous cases, have cited back to cases like Barber, like Markowitz, that predate the statute. And that's because those cases were rooted in those common law principles. And so because the statute has the language of now notice, what the statute did was it provided that notice was something that the plaintiff now has to prove. It added that burden of proof for the plaintiff. We have to show evidence that shows either actual or constructive knowledge.
And you say that in your brief, Mr. Lee, on page 19, bottom of the page. The statute adds a new element to the injured person's burden of proof.
Right.
The injured person must now prove that the business establishment had actual or constructive knowledge.
Right, but it does not do away with all the common law, and that's part of the statute that you alluded to, that it talks about. It doesn't get rid of all the common law duties that a business owner has. And so when it says something like that, that means to me that it has not gotten rid of the common law cases that predated the statute. There wouldn't be,
So is your position on behalf of your client that while the common law duties persist, the statute adds the requirement of knowledge on top of the other matters that must be proved?
It adds it in the sense of prior to the statute, there were different ways that you could prove knowledge without actually having direct evidence, meaning like inspection, maintenance, and those types of things. You could show negligent inspection, that they hadn't inspected something for
I'm sorry to interrupt you, but your statement presupposes the obligation to prove knowledge. That's what I'm trying to get to.
Right.
Are you conceding you have to prove knowledge whether or not it is alleged or shown the employee caused the condition? I want to be very precise with the question because
Sure.
I need to understand your position.
Right. My position is that, yes, I have to prove knowledge, but knowledge is, I call it a kind of a term of art. And the way that you prove knowledge under the statute, you have to go back to the cases that talk about how you prove knowledge. And knowledge, just in the constructive knowledge, constructive notice, doesn't have any aspect of that, right? But when we say actual knowledge, I think the term actual is used a lot in the sense of, well, they have to both know that they did it and they have to see it.
Well, wouldn't you agree that's the general terminology for actual knowledge? You would have to
Not
know
under
that
the
it happened?
cases. I mean, if you were looking
I
at
didn't ask
actual,
about the cases.
Sure.
I'm just
No, I
asking
understand that, yeah.
general terminology. If I was looking at the statute and it says actual knowledge, wouldn't I have to know about it?
I think the term, yes, if you looked at actual, it's like, okay, someone knows it. But when we're talking about a situation where an employee does something that causes it, I mean, it's undisputed here.
Well, and you keep
That's
saying,
where the law comes in and says that that knowledge is imputed by the fact that an employee did something, and it's imputed to the employer.
And I know, and that's what we're wrestling with.
I understand
We've
that.
got the text of this statute, and I think I speak for all three of us. The text matters, and you understand it matters,
Right.
Mr. Lee.
I do.
But I just heard you say cause. Actually, what Barber says and Dolgan says,
Created.
Create. Is create different than cause? Create to me bring into existence. I mean, and that may be cause, or it may not be. And is there baked into create a knowledge component or not?
I don't believe that there is a knowledge component baked into it, because then if there was a knowledge component baked into the create part of Barber, well, then that would mean that there would never be, it would be an intentional act always. If you termed create as you are intentionally creating something, that would be, to me, putting an intent into create that was never there to begin with Barber, or even the cases afterwards.
And I'm reading the American Heritage Dictionary, 5th edition. Create, bring into being, which to this judge suggests some volition in doing that. Wouldn't you agree?
I would agree that there has to be that if you created there, I can see where you're wrestling with it because when I look at create, it's that you're doing something, okay? You can create something, but not have the intent to do it, right? I mean, you can
create something and not know it.
You can create something by not even knowing that you're doing it. Like,
But bring into being.
bring into being means you did an action that caused something, but it may not have caused what ultimately we're looking at. If there is just sort of a high fail, I'm not beyond my time, but just
and we'll give you some more time. We're going to have a lot of questions
sure. And
for the other side too.
Right. An inference from the evidence could be that while this was going on, there was something that was done by the Mr. Clatterbuck that created this water dripping down. Okay. Now, to do that, there would have had to have been something done to a jug. Something would have happened to it. And we don't know that, but that would have caused the water to go. Well, the creation of whatever happened to the jug, whether it's broken, whether it's not, it created the condition. The condition itself, which is the water, that's what he did not have knowledge about.
What do you do with then Judge Tannenbaum, now Justice Tannenbaum's comment in Whitlow that what you're proposing, by what you just verbalized, is strict liability?
I don't believe it's strict liability, and the reason why is because there still is an element. We're talking about the element of knowledge. There still is an element of negligence that you have to prove as part of a premises liability claim. It would be a strict liability claim if all a plaintiff ever had to prove was that you had to have knowledge, or actual constructive, of the condition, and then that means you're automatically liable. Meaning that Publix, doesn't matter if this court or if the jury found that there was constructive knowledge of a condition, that means they are strictly liable. That's what that would mean.
But aren't you saying, Ms. Lee, and if you're not, please tell me.
Sure.
But aren't you saying if they created it and it caused it and there were damages, then they're on the hook? That sounds like...
No, that's not what I'm saying, because the cases are pretty clear afterwards that the elements of, you still have to prove the elements of, duty, breach, causation, damages, right? And so you still have to prove that they should have done, that there was something that was done, there was a breach of that, and then that caused the injury. So there still are elements of negligence that we have to prove. We have to show why there were negligence.
So are you saying you would have to prove that the employee was negligent in the creation of the apparel?
Either the creation of the apparel, not seeing it, not inspecting like he was supposed to.
That's knowledge.
So I mean, those are types of things that they can.
I agree with you.
But you could have a knowledge element.
That's knowledge.
Yes, you could. There's knowledge, Judge, but there's also the fact that he didn't do anything about it, right? I mean, there could be a situation where a person would have knowledge. Let's say, employee has a cup of water in his hand and is walking through the store and drops it and says, "Oh my gosh, I just dropped it." Reaches down to get it and they slip, right? A person slips at that point. Well, there was knowledge there, okay, but we have to still prove that there was negligence by that employee in what he did or did not do. Did that employee wait 5 minutes, or did he walk away and come back to it? So there's still an element that we have to show that the actions were not reasonable there. And that's why I believe that knowledge under the Whitlow case, they took a leap that I don't believe was proper in finding that, well, you have to do that because if otherwise you'd have strict liability. I don't think you would, going under how this court has looked at actual knowledge, if that makes sense. Hopefully it does. I will sit down and wait.
We will give Mr. Lee 3 minutes for rebuttal, meaning Ms. DeWolf has 4 minutes and 15 seconds extra. So, all right. So that'll be 15.
No bonus time. Good morning, Chief Judge, Your Honors. May it please the court. I'm Diane DeWolf for Publix Supermarkets. And I get from this discussion so far today that we are going to be dealing with a very handful of cases that talk about employees creating conditions. And First off, I'd like to say we do not concede that the employee here created or caused any condition. There's absolutely no evidence of that at all. But
Not the husband's testimony?
the husband,
That he saw the water dripping?
right, we saw water
That
dripping
can
from
be,
the,
so your position, that can be independent of the conduct of the employee?
correct, correct. We have no evidence, not a shred of evidence in this case, that this employee created or caused any hazardous condition. But let's start with the actual knowledge that we were talking about earlier. We know we don't have actual knowledge. Plaintiff says the employee doesn't know about it. She says it just happened, it was fresh, it was clear, like nobody was there before me. It
Let's
just came out.
assume that to be true.
Yes,
And I think that is the record.
And she says he doesn't know.
What do we do with this statement in Barber and the statement and opinion I authored in Dolgan, quoting Barber, about creation suggests that may be enough for actual knowledge.
Well, again, I don't think there's any evidence here that the employee created it, but I think we can reconcile Whitlow, and I don't know if you had a chance to look at the two cases that we sent in about 10 days ago.
Yes.
For supplemental authority. That was the Kincaid case, Kincaid v. Walmart, and Verona v. Costco. And I think they could be
The curious
reconciled.
thing about Kincaid is Judge Lott cites to Barber, and actually to Dolgan, my case, and then follows Whitlow. So obviously Judge Lott in that panel believed they are reconcilable.
They are. They absolutely are. Let's
So
start with Barber.
tell me how they are reconcilable.
Great. Let's start with Barber. Let's look at what happened in Barber, okay? We know that we have this insert, this metal insert that's rolling around on the bathroom floor, right? In Barber, the plaintiff's expert brings in the mechanism to court and shows everybody, this is how it works. Here's the mechanism. You turn the key this way, it locks. You turn the key, don't turn the key this way, it flops open, right? And there was testimony that it was flopped open and the little insert was rolling around on the floor. And then they say, only the employees have access to this, only the employees. So we know only the employees have the key, only the employee could have not turned it. What's that? Negligence. And if you look at the Verama case too, it explains the reason why there used to be that if an employee creates a condition, it's negligence, because presumably if an employee drops something, they know they dropped it.
And that seems to be what Judge Tannenbaum is saying when he is now Justice Tannenbaum, but when he references Trussell and saying that's what Trussell was saying too, the Supreme Court of Florida. And so your sense of it is typically when someone does something like that, they would know they did
Well,
it.
sure. She doesn't turn the key and it flops open and things fall out. I mean, you're there. You should know that. You did it. You didn't turn the key. One, negligence, and knowledge, because the metal thing fell out on the floor. You should have heard it. You were there. And also, we had evidence there because we had someone who came into court and said, only employees do this. This is the way it works.
So the statement in Barber that's been cited over 70 times, and Dolgan's statement about creating the dangerous condition, point one, you would say that didn't happen here. There was no creation by the public's employee. But you would say the creation, that statement would typically happen when the person creating it knew they were creating it at the time.
Absolutely,
That's where
because
that comes from.
if you look at Dolgan and Barber, you don't have to talk about knowledge. You don't have to talk about negligence. It's obvious on the face of the opinion.
And Dolgan, there was a wet floor sign. They knew it was, there was
a wet
water on the
floor
floor.
sign. There was an employee who testified, I brought in those U-boats when it was raining. I put up a wet floor sign. Then there's another employee that comes in and says, I took the U-boats out and I moved the wet floor sign. We have testimony. We know he knows. He told us he knows. We know he was negligent. He told us he was negligent.
That sounds like actual knowledge.
Yeah. And we don't have any reason to talk about that because in both Barber and Dolgan, it's obvious on the face of the opinion, right? It's obvious they knew. It's obvious they were negligent.
So you would say, consistent with what then Judge Tannenbaum said, that there is, and there has to be a flavor of knowledge with actual knowledge.
So look at Whitlow, right? Yes. We have a stretcher that's wet. We don't know why it's wet. We don't know if the employee created the wetness. You know, it would be a different story if they said it was wet because that orderly who was pushing that stretcher had negligently tied up the IV string or something, and that's what was dripping all over. They don't have any of that. All they had was an orderly pushing a wet cart. We don't know what that wetness is or where it came from. Did the orderly create, he was in control of the cart, but did he create the wetness? No. It could have been IV fluid, it could have been rain, it could have been bodily fluid, who knows?
But applying it to this case then, we don't know if the Publix employee caused the containers to leak, but if he has the containers on a U-boat and the U-boat is being pushed across the floor and that is dripping water onto the floor, is he not creating the peril by moving the container from point A to point B?
That's not what happened. And I too reread the testimony driving in the car yesterday.
That sounds
The deposition testimony. But he wasn't pushing a dripping cart. The cart was stable. So you've been in Publix, you know, in the back of the store, that's where the storerooms are, right? That's where things get loaded, that's where the product is. So they take the U-book out of the back. I mean, I can say this back, but it's easier to face you. This is the back, this is the front where the registers are. So he brings the U-boat with the water jugs on it out. It's not leaking. And we know it's not leaking because he pulls it up. Here's where he's stocking everything. He pulls the U-boat up. He sits it here. He walks to the other side of it towards the front of the store. Mrs. Christie comes from this way. Before she gets to him, she falls in her 4-foot puddle of water, right? Mr. Wainwright doesn't come from this way. He's coming from this way. He's coming from the back of the store because they had to go back and get water, but she's too slow and he doesn't want to wait for her, so he went to get butter. So he went to the back of the store where the dairy is. He was coming up this way. And so he was asked during his deposition, did you see the water when you were coming? No, I didn't come from that direction. So he says there's a spring, it's flowing this way towards the front of the store. So we have to believe.
He also says it's dripping.
Dripping, it's a spring, but it's going that way. It's not from the direction he came.
But dripping is different than a spring. You would agree with that? I mean,
Well,
a slower leak actually helps Mr. Lee. A spring actually helps Publix, meaning it wasn't there very long.
Yeah, I think
You would agree with that? Or not?
he says both things. Which one do we go with? He says it's dripping from the cart, and he also says it's like a spring all the way down the aisle. She says it's a 3-foot puddle. I don't think it matters because in any event, it's clear, it's fresh, it's new. It's like it just happened. It's like nobody was there before me. There's no footprints, there's no dirt, there's no cart marks.
Is the sheer size of the puddle circumstantial evidence?
I don't think so. And I think if you look at the two cases that they cited in their brief for the size, you know, of the puddle matters, they're both cruise ship cases. We know in both cases exactly what happened, where the water came from. The first one,
Why should it matter if they're cruise ship cases versus this?
they don't. That part of it doesn't
Okay,
matter.
okay.
But the first case, it was on a cruise ship. They came into the game room to play ping pong, and she went back to get a ball and fell in a huge puddle of water, like a 3-4 foot puddle of water. It was determined in that
So
case.
3 feet's huge.
Well, it was.
I mean, if I pulled out a tape measure on this bench and measured 3 feet,
In this particular cruise case, it was big because they determined that it came from a trickle that was coming from the ceiling above. And for a trickle to create a 3 or 4 foot puddle, they determined was
That's my point. If it's dripping and it gets to 3 by 3 or 4 by 4, that suggests it's there for a while, and Mr. Clatterbuck is there. I mean, that's undisputed. He's in the area.
He's in the area.
Okay.
Correct.
So what do you do, again, where I started with Mr. Lee, you've got drops, according to, I read his testimony last night from Mr. Wainwright, drops down the aisle, a dripping U-boat, a huge pool of water, and the Publix employee in the area. Isn't that classic constructive knowledge, or not?
It's not, Your Honor. One, because, this is a clear, completely clear liquid. This is not this banana that was in the supplemental authority that was in the front where there's two employees stationed there.
You would say that the consistency of this is not indicative of something that had been there a while, but if the water was dripping onto the floor, that would suggest time.
I don't think so. I mean, I don't think
why
we
not?
can
I don't
really, I
understand
think
that.
these are mental gymnastics, really, because we don't really know we don't have an empty jug. We don't have a broken water jug. We don't have a jug that has a broken cap. We don't have any indication that it came from a jug at all. What if it dripped from the ceiling? What if it, came from somewhere else and then finally found its way down?
To borrow your hypothetical then, if it dripped from the ceiling, much like the cruise ship case, then that's a lot of drops to get 3 feet by 3 feet. That's the gist of the questioning we're going through. I mean, whether it's the cruise ship case, whether it's Publix, if something is dripping on the floor and it amasses a volume measuring 3 square feet, that necessarily of logical force dictates the passage of time, which is relevant to unless I'm just sitting here confused.
How about if this was a jug that spontaneously combusts, right? And, with this box cutter, speculation, right? First of all, they're not in boxes, right? On the U-boat, they're in crates. He says they're in crates. He says, I empty my crates, take my crates to the back, I stack them back up in the storeroom where they belong. He doesn't say I break down my boxes and put them in the dumpster.
Well, the problem with the spontaneous combustion, and you would be right, if it combusted, then we would know. And it would certainly inure to your client's benefit, but we've got drops down the aisle, which suggests, inferentially, that it's from the same U-boat. I just don't know how you can reconcile the drops down the aisle, the dripping U-boat, the huge pool of water, and the employee in the area. I mean, what do you do with the drops down the aisle?
Again, we don't know, and that's the problem, because the U-boat never went down the aisle that way. The U-boat's here. So if we had a spontaneous combustion and we have a big 3-foot puddle, then that came and it was there and it came very quickly, right? So then maybe, think about a water jug. So it splits up here, so all this part of it spills out really fast, and then this part is just dripping because the slit in the thing is up here, and so the rest of it is just sort of dripping out.
Well,
Maybe
back
you
to
could have
Judge
both.
Stout. So,
But the drips down there, I don't know.
Take away the aisle. Judge Stout's point, a good point. Dripping water leading to a huge pool of water suggests time when you've got an employee standing right by the U-boat, doesn't it?
I don't think in this case you can go there. I mean, I think in the 2 cases where they suggested time, they said it was a very small trickle coming from the ceiling and there was a huge puddle. Here we have dripping from what? We're not sure. We're taking for granted, as we have to, that the U-boat was dripping water, but we don't know whether it came from a water jug. We have no idea how drips got down the aisle because the U-boat never went that way. And it was clear and there were no footprints and nothing else. So maybe those drops came from something else. That's the point. These are mental gymnastics and we don't know. We don't know where those other drops came from.
But it's not for us to know 100%, and I know you know that. I mean, it's
Well, these
in
are
a light most favorable to the non-moving party. That's what the case
Absolutely.
law, starting with SCOTUS and Anderson. I know you know that. So if we look at this evidence in a light most favorable to the non-moving party, is there not a jury question on the constructive notice? Now, actual notice may be a completely different paradigm. But why is a dripping U-boat with a large puddle of water with an employee in the area not enough, based on the cases, to say it was dripping for a while?
And the other case that they cite in their brief for the fact that it was happening for a long time because the size of the puddle matters was 3 cruise ship employees, and they were doing some maintenance on the pool, and they were splashing water everywhere, just splashing water everywhere. They didn't do anything about it.
That was an actual knowledge case, wasn't it?
No, I don't think it was.
I thought it was, but
No,
maybe I stand corrected. I will tell you, There are probably a dozen cases that deal with large puddles. I know they only cited 2 of them. I saw any number of federal cases saying the same thing. So it sounds like the consensus dealing with time, if you have something that is a slow leak that leads to a big puddle, that logically, inferentially suggests time. So I mean, if there's not evidence of dripping, then you're right. If it's a spring, if it's pouring out, that's one thing. If it's dripping, that suggests time.
Well, and again, the same person said both things. So what is it? Was it dripping? Was it a spring down the aisle? Was it a 3-foot puddle? And, you know, those are disputed facts, but are they material? I don't think so.
Why wouldn't those be material?
Because it doesn't matter. We still really have zero idea how long it was there, and we have plaintiff's testimony who says it wasn't.
I mean,
it just
based
got
on
there.
The 2 cruise ship cases, they say it does matter if it was dripping or not, or how it
Because
got
they
there.
had evidence there. They knew how it got there. We don't know how it got there.
Well, he
We don't have a
testified
clue.
it was dripping on the floor.
It was dripping on the floor from what?
Didn't he say from the cart?
He said from the.
Said from the cart.
I don't have the record. I could read you the record, but he said it was dripping.
He said there's water dripping from the cart, but from what? We don't have a broken water jug here. We don't have a jug that tipped over. We don't have an empty jug. We have nothing like that.
But
We
if it's
have
dripping from the U-boat, maybe, is that a distinction without a difference? I mean, this is the public's U-boat, is it not?
It's a Publix U-boat, yes.
So if
It's a standard. They call it a float.
And yes, and that's the right term, correct? U-boat?
Float, yes.
Float, what does Publix prefer we refer to it as?
It's float.
Okay. But water is dripping from the float, correct?
That's what Mr. Wainwright says, yes, correct.
And I know you dispute that, but.
No, I didn't, we don't dispute that.
Oh,
If he
well,
says there's,
dispute
we'll
that,
take,
because Clatterbuck says it was not, but.
he doesn't say that. He said he didn't know.
Okay, so that's even better for Mr. Lee. The fact that Mr. Wainwright said it was dripping and Mr. Clatterbuck says, I don't know if it was dripping.
He had no knowledge that there was water on the floor. What Mr. Clatterbuck says is, after they were all gone, they got up and walked away. Another customer came and showed me some drops of water over here, which I cleaned up with my 2 paper towels. That's what he says. You know, they don't have any, there's been, the only speculation that they have as to where this water came from is that somewhere, sometime, somebody used a box cutter, which is pure speculation.
But I appreciate what you're saying. You're a very good lawyer. But you've got an eyewitness watching a U-boat, dolly, float, dripping.
Mm-hmm.
I mean, that's undisputed, isn't it? For Mr. Wainwright watching this dolly dripping.
But we have zero evidence that it was created, caused, or by a Publix employee.
But does that matter for constructive knowledge?
Yes, I think it does. We have a clear liquid. We're not dealing with grape juice in the Nike Bray case. We're not dealing with a banana. We're not dealing with a grape. We're not dealing with any of those things. We're dealing with clear water.
But to the Chief Judge's question, here, if you read the statute, and we talk about actual knowledge or constructive knowledge, and the text of the statute bears this out, the entire forest in which knowledge exists for theory of liability is the failure to remedy that, either of which you actually knew or constructively knew or should have known. It's the failure to remedy that is the theory of liability. I'm grappling with, if common law duties survive under subsection 2 of the statute, then is there a separate strain of liability when the peril is caused by the conduct of an employee? And I will sit here and tell you, that is not an easy question to answer, in all candor with you, in the language. And that is what a lot of this goes to. Constructive knowledge is certainly one thing, but actual knowledge, as understood in Barber and its progeny, and then as it pertains to the text of the statute written afterward, the knowledge component, to me, Justice Tannenbaum has a view. It's a question potentially that it, in this case, or perhaps not in another case, may need to be reckoned with.
Well, it's not just, Judge Tannenbaum anymore, right? So we also have the 4th DCA, and Judge Lott has agreed with that. And then we have the 11th Circuit, who has come in and said, this is the law of Florida now, right? It's taken this as the law of Florida. If you have an employee who has no knowledge whatsoever, then the create never comes into being. Without knowledge, then the create element doesn't appear.
Is there anything?
That's what Veramo v. Costco says. That's what the 11th Circuit says in Veramo v. Costco.
Is there anything, or is this all wet? The whole create thing, the nature of what create means. Does that mean to you something suggesting knowledge, create versus cause, or not?
No, not to me. Creation is, let's look at Whitla. We've got an orderly pushing a wet stretcher. He created, I guess, the puddle on the floor in the elevator, but he had no knowledge of it. And we have absolutely no evidence in that case. Nobody came forward with anything. Nobody brought a box into court and showed how the mechanism worked and how an employee had to have been negligent for it to be flopped open that way.
What does sub 2 of 7680755, what does that mean? This section does not affect any common law duty of care owed by a person or entity in possession or control of a business. What does that mean? Why is that there?
It doesn't interfere with any common law duty of care that you have. This is not a case we cited in this brief, but for example, no, that wasn't a premises liability case. So yes, you still have a duty of care to keep your premises in a reasonably safe condition.
To Judge South's point, and I wrestle with this too based on sub 2, is there an additional band of potential liability out there outside of sub 1 here or not?
I think it would be very specific. I think all of these premises liability cases are very fact specific. I can't think of one off the top of my head right now to give you. I will say that you can look at the Pembroke's Lakes Mall case, which very clearly struggled with negligent maintenance, negligent mode of operation, negligent inspection, negligent warning, all of those things, and said that's no longer how you prove premises liability. That's 768-0710. That is not 768-0755. And we can't apply this retroactively, and it very clearly explains I think Glaze v. Worley, Judge Wolf's case, I think he says the same thing.
I'm familiar with the case you just referenced, but based on the text, where does that come from? Because the text seems to suggest that this common law duty of care is still out there. Well, it doesn't suggest it, it says it. So I'm having trouble with those cases that just categorically say, this is no longer what it used to be. And I get it, it's a different statute.
Yeah,
but the statute says those common law duties that we all know about, the duty to provide a reasonably safe place to shop, not safe, but reasonably safe, that those things still exist. So, how does that apply to this case, Christy?
I don't see that we have any breach of any common law duty of care here. We have a employee who is taking gallon jugs out of his U-boat crates and putting them on the shelf. He has no idea that there's water that has gone behind him and down the aisle this way. It's perfectly clear. And moreover, it does seem like it just happened rather than accumulating over time, because there's no dirt, there's no footprints, there's no car tracks, there's no water. And plaintiff says this, it looks brand new, like it just happened before I got here. So, that's what we have. We don't have any indicia of length of time. And as far as drops down the aisle, that's inexplicable unless it was a spring down the aisle, unless it was something that spontaneously combusted and was flowing down the aisle. That's the only way it makes any sense, unless those drops down the aisle came from some independent source. So, again, this is mental gymnastics. These are the cases we don't send to a jury because there's no evidence of anything. There's no evidence that the employee created it, caused it, knew about it, either actual or constructively. Zero. There's no evidence of anything. There's a perfectly clear substance, and that's why the court granted summary judgment in this case.
All right, thank you. Your time's up.
Thank you, Your Honors. We'd ask that you affirm.
All right. Mr. Lee,
Yes, sir.
please proceed.
Sure. I'm happy to answer any questions that the court has. I did want to just touch on a couple of things. We of course have evidence that the water was dripping down the aisle, and I think the assertion is that, well, there's no way that could have happened. Well, of course it could have happened. It could have happened that he was pushing it down the aisle and it was dripping as he was going along. That's, I mean.
She would say he came from the other direction. What do you make of that?
No, because what I believe that what the evidence shows with Mr. Wainwright is that his wife was coming one way up the aisle towards the U-boat, and she slipped and fell. And he had already left her to go, I think, get butter, if I'm not mistaken, and was coming up the other way and saw it. And then as he's coming up, this is in the testimony, he looks at it, he sees it's dripping water from the U-boat down onto the floor. He sees the bits of water, and he actually tells the employee, hey, your U-boat, he calls it U-boat, the float, is dripping water.
So you would say that when he is talking about water in the aisle, it would be the direction that she had come from?
That she was coming from, because he's looking, you know, his
Looking
vantage
down the
point is
aisle.
coming down toward, she's kind of coming towards him. So he's looking down the vantage point of where she's already walked, and he's seeing whether it's because of how he's looking or whatever the case, he sees it drips down the aisle.
And that was the direction the U-boat was coming from?
Was coming from, because it seems pretty clear that he saw it dripping from that point, and he was very clear, despite multiple instances of defense counsel trying to get him off of it, that it was coming from that U-boat. It was dripping down that U-boat onto the floor. That's where the water came from. So he was very clear about that. And whether it's from a water jug that was cut, whether it's from, I mean, frankly, anything that could have been on that U-boat, I don't think that matters, because the U-boat, just like Barber, was under the exclusive control of Publix. There is nothing in the record that says that, oh yeah, everybody uses these floats. They use them for that. And so just like Barber that said, look, you have exclusive control over something, it happened because of that. You created the condition. That's how I think this court can square this case right along the line of Barber, and frankly even Doty as well. Because I don't believe that this court would want to say that you could only prove actual knowledge by having an employee know that they did something and did nothing about it.
You could only prove actual knowledge by having actual knowledge.
Meaning I see
So that does- that's
I know that I dumped something on the floor, and I just didn't care as an employee, and I'm like, well, whatever, someone's going to take care of that.
Then Judge Tannenbaum, now Justice Tannenbaum, talks about in cases where there's not overt knowledge, there could be an algorithm, calculus, where the employee, just the way they dropped it, maybe, should have had actual knowledge.
Right.
And so, but still there's a knowledge component.
There's a knowledge in the sense, and I think the knowledge is kind of what we're wrestling with, right? And maybe that's where Barber talked about creating it, meaning that, you know, that the knowledge can be done by the creation of it. If an employee, if it was proved or at least inferred through reasonable evidence that an employee created a condition, it does not matter then whether the employee knows that he created that particular condition. Because the employee, meaning the property owner, created it, they're going to say under the law that you have knowledge of it because you created it. Whether or not that ultimately the employee looked at it and saw it, If it's proven, at least through the evidence, or a jury can determine that it was created by an employee, that goes up to the property owner, and that could prove actual knowledge, and the statute doesn't take those cases away. We would ask that the court affirm, or excuse me, reverse. Thank you.
Hey, thank you, Mr. Lee. Ms. DeWolf, it was well presented on both sides.